everybody, welcome to another episode of Ask Me Anything with Sky Unlimited Law. I'm going to answer your estate planning, asset protection, business succession planning questions that you have for me today. All right. First question. I have a will, but I'm interested in replacing it with a trust for my heirs. My assets are modest. They include a house in Little Egg Harbor, sounds like it's somewhere in the East Coast, now worth maybe $300,000 or less, and investments about $40,000. I live in California, so how can I set up a trust that covers my house in New Jersey? Oh, Little Egg Harbor is in New Jersey. I didn't realize that. House, which I bought in 2002 or 2003, has a small mortgage, which I paid off in 3 years. I have tenants in it now. Okay, so you used to live in New Jersey. You own your home. It's got a small mortgage. You'll pay it off in 3 years. You have a will. What is it like having property in another state while you live in the current state that you live, like California? Well, if something happens to you today, your will has to go through probate for all your assets in California, but you are also going to have to open up a second probate in New Jersey. Oh, that sucks. Double the court fees, double the legal fees, double the filing costs, double everything. Totally sucks. So yes, you probably do need to set up a trust now that you set up your life here in the avocado state. And what you might want to do is set up your trust here in California, and as easy as go to an attorney or have your California attorney help you transfer title to your property in New Jersey to your California trust. Totally doable. A trust, no matter what state you create it in, can hold any property you want around the world. Now, before you go moving your Mexican coastline real estate or your Canadian property into your trust, keep in mind those countries on other parts of the world also have their own laws, and they might not recognize a U.S. trust. They might say, imperialists, what are you doing? So even though your trust can hold any asset worldwide, it might not be doable in other countries. But for within the United States, absolutely. If you have real estate all over the United States, it can all be titled to your one trust, avoiding multiple probates in each of those different states. So this is a very good time for you to do that. Now, when it comes to your mortgage, if it's your primary residence, we don't care about the mortgage. We'll move the home into the trust. But if it is your rental property, like this New Jersey property is, you have tenants in it, there's federal law that protects you, but then there's also federal regulation that contradicts federal law that doesn't protect you. And it says the bank can accelerate the loan on your mortgage when you make a transfer. So what do? How do we answer this question here? Well, first, we don't take the risk on trying to fight a bank in court. So what I suggest you do is just reach out to your bank, let them know you're going to transfer it into a revocable trust, a living trust that you're creating for your estate plan. And most likely they'll say, okay. Most banks, they don't like people transferring homes into LLCs whenever there's a mortgage. Why? Because the bank doesn't see who owns the LLC, and they don't see how title of an LLC can transfer privately, and they don't want to have to go after a total stranger for a foreclosure on a property that's inside of an LLC. Now with a trust, it's a little bit different, especially if the trust is revocable, irrevocable. What we're talking about here, what you're trying to set up for yourself, is called a revocable living trust. I've never had a problem with banks having an issue with real estate investors moving their rental property into their revocable living trust for estate planning purposes. So I would just say we contact the bank, let them know, see if they want to ask any questions or anything like that, get their approval, and then we move it into the trust. If you have more questions, please reach out to me at info@skyunlimited.law, and I'll be happy to help you out. Next question. How do I remove myself as a substitute agent for both financial and healthcare power of attorney documents? Okay. Someone has listed you as their substitute agent. They probably listed a primary agent and you're the successor or something like that. And you probably don't want to do the job. You don't want the responsibility. First things first, whenever your name is listed on one of these documents for someone else, you are not legally obligated to comply. You do not have to step into the shoes as agent on behalf of someone else. But I highly encourage you to let the agent know that you don't want to do the job. Okay, so let the principal know that you don't want to do the job. Let the person who's putting you in as their agent for their healthcare or for their financial, because they're literally trusting you. They're trusting that you can do this for them. If you don't want to do the job, you should let them know. They're going to be pissed off. Okay, so that is the simple answer there. There's no way to take yourself out. It's their document. It's their legal right to name you as a potential successor, but that doesn't mean you're legally obligated to jump into the shoes of successor when that time comes. And it's really nice if you know that they've named you, go ahead and let them know.